Merci pour votre attention. I look forward to our general discussion. But first of all, we will have a very interesting session with three PhD candidates who all work on space law from different disciplinary perspectives. So we will start with Alban, who is a PhD candidate at the University Panthéon-Assas and at the Collège de France. Then we will proceed with Katia, who is a PhD candidate at the Université Paris-Nanterre. And finally, we will hear from Yann, who is a PhD candidate at the Université Jean Moulin-Lyon 3. C'est bien le 3. OK. Très bien.
So, hello everybody, and I first wanted to thank Professor Besson for letting three doctoral students the opportunity to comment on each leg of this colloquium, namely public international law, philosophy, and with myself, private international law. As a first point, I wanted to say that private international law sets the property title into motion, and this constitutes its specific utility for a discussion. Private international law, though from a domestic perspective, first, is concerned insofar as the property title bears an international dimension in respect to its object, namely, and we spoke of it since yesterday, resources situated in an area beyond national jurisdiction. But also because, and more importantly, ultimately, property titles are not destined to remain indefinitely within their forum of origin. A property title is intrinsically made to circulate, and it is actually doubtless that during the circulation, the defective character of such a property title becomes apparent. Indeed, it may be acceptable, at least provisionally, to acknowledge that such a property title constituted of a resource beyond national jurisdiction is valid and effective within, and only within, originally, the domestic law of its forum of origin. On the perspective of that domestic law, the property title do exist. And it exists on a basis which is not really actually Article 2 of the Outer Space Treaty, we'll get to it later on, but much more Article 6 of the same Outer Space Treaty, allowing states to legislate on national space activities they have inside their jurisdiction. Yet, once such a property title on space resources is transferred into another forum, may it be for an international sales contract, for example, the matter becomes significantly more complex, since neither recognition nor enforcement of the property title, as sometimes has been said throughout the colloquium, and as Professor Raddy just also said twice in his conclusion, this neither recognition nor enforcement of the property title are assured in the receiving forum. And I think this is precisely because the title may be deemed contrary to ordre public international of the receiving forum, insofar as it was constituted in violation, or at least sitting uncomfortably with international law and Article 2 of the Outer Space Treaty, which we have been referring to since yesterday. This ability to be controlled, this ability to have the validity of the property title to be controlled through ordre public international once leaving its original forum to go to the destination forum can be seen as a decentralized control of the validity of a property title constituted in relation to an international resources. But this control is by no means guaranteed at a time when the idea of appropriation, not merely possible but also legally valid in international law, is increasingly being asserted as a shared opinion and ultimately lessening the possible inconsistency with ordre public international. But more fundamentally, still, I think the question that emerges once the surface is scratched is much more that of the relationship between private law, and more specifically private international law, and public international law. That is to say, more precisely, between a public international law of outer space and a private international law that seeks to apprehend space activities. There is a slight difference in the formulations of the two things, public international space law on one side, and private international law interested in space activities on the other side. The difficulty, however, lies in the fact that in the rare instances where these two fields are not treated as hermetically distinct, and this colloquium is one of such exceptions, it must be observed that the relationship between public international law and private international law in outer space continues to be conceived in accordance with the classical patterns of interaction between those two disciplines. This, I believe, is actually the stumbling block upon which debates founder, and the basis of a continuing fruitless dialogue between public international law of outer space and private international law concerned with space activities. And if the issue appears insoluble, it is because the real difficulty lies probably in the way the question is posed. We ask ourselves about the interaction of public international space law and private international space law with parameters of the debate dating from the 20th century, not enough taking into account all the research that has been made since, especially by Professor Mills, about relations between public international law and private international law. And probably the moon and outer space, and the infinity of outer space, can be an isthmus where the terms on which public international law and private international law articulate might be questioned on a new way, on a new perspective. So this ends a private international law perspective on the question, but as Paul Valéry, who once taught in this room, used to say in one of his Collège de France courses, in our field of research, a new problem is actually a result. And about relations between public and private international law, I'm very happy that private international law's N+1 speaks right after me, namely Katia in public international law.
Thank you, Alban. So, Katia, no pressure on you.
Absolutely not. Thank you very much, Alban. And thank you, Professor Besson, for giving us the opportunity to us young scholars to intervene in this great colloquium. And thank you, Professor Yann Robert, too. I'd like to focus perhaps a bit more on the problem within public international law, and that also means to introduce what do we do with private international law and national law as a whole within international law. So, as you know, the legal regime in international law can be seen as prohibiting appropriation and sovereignty, and especially for space resources, of course. And the problem is, how can a state allow appropriation in its national legislation while not being sovereign? Is there a legal technique allowing a state to give rights upon something that it has no sovereignty upon? And I think there is not. And as Professor Hober said in his presentation, national legislation allowing appropriation when public international law does not can be considered as an ultra-vires act. But mostly, and you mentioned it just before too, there is a legal gap between sovereignty, jurisdiction or quasi-jurisdiction, and property. And Alban said it just now, the relationship between public international law and private international law in this question is at stake. And to be more precise, the relationship between public international law and national law as a whole. Well, first, the implementation of international law in national law varies, but mostly for 5 recurrent national legislation that brings us a lot of problem here. They argue that they respect international law. And indeed, I believe the solution is perhaps in international law. One option is to change the main interpretation of the Outer Space Treaty. If everyone agrees that the Outer Space Treaty allows appropriation, well, the problem disappears. However, when we look at the different initiatives, we have multiple interpretations of the Outer Space Treaty. Most of them are in a minilateral and centralized context, mostly the Artemis Accords, but also the ILRS. But one point that I think we should emphasize on is what about the others? What about the states who are not part of the Artemis Accords and are not part of the ILRS? Well, if we emphasize a little bit more on those states, on those who are not part yet, at least, in the evolution of interpretation of the Outer Space Treaty, perhaps we can question too our conception of humankind in the context of the Outer Space Treaty. And I believe here, it is perhaps a strong stance, I don't know, but that we have all been a little bit biased in the way we see international law, see public international law, and especially space law. Because, why are we biased? Because we are all speaking English here, we are taking place in a European-centered context, and perhaps the discussions would have been a little bit different if we had, I don't know, some Chinese scholars or scholars from the Global South. And I just wanted to emphasize that perhaps it would also be interesting to have the same conversation on property in outer space from other perspective of public international law. This element of how we address international law is not limited to space law, of course. As such, the stakes are not limited to space resources. It is a larger stake on how we address international law, or just sometimes portion of practice of international law. How is it created and who is it made for? Thus, the silence of states can be seen as a position making an argument against the Artemis Accords and other situations, or not. Do those states are just following the general interpretation of customary law and of the Outer Space Treaty for those who are a signatory? In any case, we have multiple interpretations of the treaties that are not compatible, and I'm not talking about the Vienna Convention on the Law Treaty here, but also how do we assure that outer space remains a province of humankind in this setting, and more precisely for all of humankind, and this is my second point. States are understood as the representative of humankind in the international society or international community. And as Professor Moore said, they are failing to regulate capitalism and some of them do not defend humankind, but only a part of humankind, due to the inequality that an unregulated capitalism can create. So the undertone here is also to question the position defended by many, which is utilization and exploitation of space resources, whether by public or private entities, is in benefit of all mankind or only a part of mankind. I believe the solution lays in multilateralism. Of course, I'm not the only one thinking that, and also in a depolarized conversation, and in opening a discussion about the subjectification of private entities. So you mentioned it before, so I can finish a little bit faster, but perhaps we could think a little bit more about the international responsibility of private actors that are asking for new rights in the international law. Perhaps we should think also about their obligations in international law. The other final points that I wanted to address is a reminder that we do have a system that avoids property on celestial bodies' resources. They concern the non-material resources with the ITU. The ITU does have regulations for slots near the moon, for example, for the Lagrange points. So there is some solutions possible in the multilateral organism that takes into consideration both the states and also private entities' interests. Thank you very much. As you have seen, we have moved from private to public, and now we're moving to the philosophic part.
Yeah, the floor is yours.
Thank you. And I'd like to thank once again Professor Besson for hosting this event and allowing me to share a few thoughts, in particular, two issues from a political philosophy perspective. They mirror, I believe, two challenges regarding private property in general. The first challenge is a matter of definition. And the question I would like to ask is what concept of property is used to describe rights over outer space resources? The common understanding seems to be the full liberal ownership, which grants large powers to the owner. But is such a concept necessary? Regarding celestial resources, isn't the bundle of rights approach more fruitful in grasping and dividing the diverse interests related to these resources. For example, does scientific inquiry, on the one hand, and future economic exploitation, on the other, require a property entitlement in all its incidents? Or is it not a good reason to redefine property, following, for example, an operative conception of property, such as defended by Laura Underkufler? Or maybe a further reason to dismiss the concept once and for all, deemed disintegrated by the positive law. But the most important is the second challenge, most important to me because it's the thing I work on. The second challenge is a matter of justification. And I assume sheer force or technological superiority is not deemed a good justification of property rights. What could provide a reasonable ground for private appropriation of celestial resources? So there are obviously strong economical incentives to frame outer space resources into property holdings. But what political reasons do we have to accept it? And I will address one particular line of justification, the freedom-based justification. Invoking freedom seems to provide a solid normative ground, at least for liberal societies, to accept celestial resource appropriation. The problem is such a reason goes both ways. Free access and exploration may help to justify appropriation just as well as non-appropriation of space resources. So how should we interpret the idea that outer space shall be free for exploration and use? Freedom may be conceived, on first glance, as an absence of interference. And as such, freedom is impaired by constraints to action, or in case of spatial activity, constraints to extraction and commodification of resources. As such, international authoritative institutions or any regulation generate such constraints on private companies and would raise the amount of global interference. And a free outer space would look like an unconstrained or minimally constrained access-free territory for any endeavor. Celestial resources, considered as res communis, would stand free for the taking, following the adage quoted by Professor Massimi, finders keepers, losers weepers. There are many values we can oppose to such a justification. We could contest it through value of inclusion, protection of the environment, principle of justice, or the benefit of all mankind. A classical defense of property rights, of private property rights, that also applies to space resources, would contest the importance of these values for the sake of liberty. But is it a necessary outcome of the liberty value to promote commodification or privatization? Are we therefore condemned to leave the liberty or the freedom argument to lunar grabbers? If not, what conception of freedom could we invoke? And one possibility I would suggest is to define freedom as the absence of domination. Political freedom, then, exists when no one stands under someone's thumb. That is, in a situation where some dominating party can arbitrarily interfere with impunity. Such a concept suggests an ideal of equal standing and is related to what has been called relational freedom. My main inspiration here is Philip Petit's version of republicanism. So the freedom that should be provided for scientific and commercial use of space resources is generally understood through the classical liberal lens of non-interference. But to what extent could this classical concept of freedom applied to spacefaring activities produce domination? Henceforth, to what extent might the classical liberal approach actually impede the principle of free exploration and use for all states? Can a Republican approach based on freedom as non-domination be applied to outer space? And in that case, the deep power asymmetries that could emerge from private-public spacefaring activities and resource appropriation would not be a dire consequence of freedom, dire consequence for equality, for justice, or for the benefit of mankind. I said would not be a dire consequence of freedom, but a threat to freedom itself. And liberty would cease to provide the sacred ground for the lunar-grabbing ventures. Thank you.
Thank you very much to the three of you, and thank you to all the speakers. And of course, thank you to the participants and to the audience.